On the 29th of June, the government issued a consultation on firearms licensing that you can respond to. It's going to run for 8 weeks, and we're now about 3 weeks away from that deadline, which is the 24th of August 2023. Although the consultation isn't as big and as serious or perhaps as dramatic as we first thought it might be, it is still one of the most important consultations in a decade or over a decade. So it's important you go to the link in the description and fill that out and make your voice known. If you're a firearms license holder, shotgun license holder, or know someone who is or aspire to be a firearms license or shotgun license holder, please fill this out and make your voice known. In fact, if you have any stake in this game, make your voice known. Today we're going to be going through that consultation question by question and perhaps helping give some guidance on where to go with its yes or no answers, just with a bit of information to help guide you through it. Once you've gone into the Home Office survey.homeoffice.gov.uk/s/firearms-licensing, you will get to a list of questions. The NGO suggests that your responses may be as follows, but again, you are your own person. Please take your own mindset into this. This is what surveys are all about. Question 1. Regarding the establishment of a new police power to enter homes without a warrant to immediately seize firearms, shotguns and ammunition when certificate holders are uncooperative. That first question is a difficult one. And genuinely, I think the answer should be no. And the NGO thinks the answer should be no. It's a complex area of the law anyway. And honestly, the police already have powers to enter your property without a warrant if there's immediate threat to life. A new power really shouldn't be granted without extensive safeguards for certificate holders and others who live at that address. And moreover, if that power is granted, there should be a right to an appeal that is dealt with very quickly. Nobody needs to have their guns taken away without a warrant having been issued, without those sort of levels of safeguarding having happened, and then not be able to actually challenge that if it was wrong. You don't want to be without guns or without your license for maybe a few years if that was to happen to you. And as such, the answer should be no. It's a vastly more complicated answer than a yes or no, but given that choice, no is the right answer there, we feel. Question 2. Do you consider that the prohibition on possessing firearms should be changed from one that is based solely on length of custodial sentence following conviction to one that is based more on the nature of the offence? Yes or no, the NGO has no strong views here. The prohibition from possessing any firearms or ammunition for a person who has been sentenced up to a certain period of imprisonment has served to date the public very well, and as such it doesn't necessarily need to change. Certainly the police already apply a suitable person test, so there's already levels of safeguarding in place there. If you feel that perhaps it should be done more on the nature of the crime, that's down to you. Obviously, there's different types of crime out there and different custodial sentences for each. Some you definitely might not want having a firearm, and some may be a little bit different. The reality is that there's various and new methods of dealing with offenders, and that whole area of the law needs to be updated anyway, so yes or no, down to you. Question 3. Do you consider that the renewal period, currently every 5 years for a certificate, should be kept under review? If so, is every 5 years the right period of time, or should it be changed to a shorter period of time? You're answering yes or no to the first half of that question. Do you consider the renewal period should be kept under review? And the answer to that should be yes. You then have a multiple choice thing that gives you 5 years, the current period, less than or more than. More than 5 years is the correct answer, certainly the NGO and I think. There are a lot of reasons for that, but mostly the police have linked databases now, meaning that before, when they'd only really check through your stuff every 5 years, they now can check things instantaneously. Flags come up on your system instantaneously. Certificate life could definitely be extended, and I think we'd all welcome that. Question 4. Do you consider that people applying for shotgun certificates should provide 2 referees? Yes or no? The NGO has no strong views here. Currently, firearms license applications need 2 referees, and shotgun certificate applications require 1 referee. I don't think it's necessarily a bad thing to have 2, but I don't know if neither is it completely necessary. This is down to your personal preference. Question 5. Do you consider that at least one of the referees should be a person of certain standing in the community? This could include public officials, members of a regulated profession, officers of registered shooting clubs, National Farmers Union representatives, landlords, land managers, vets, or surveyors. Yes or no is the choice here. And the NGO and I think the answer should be no. The applicant may not know a person of particular standing in the community, and it's more important that the referees know the applicant well enough to give a suitable character reference than they are of a particular standing in a community. Question 6. Should a referee be able to demonstrate a good knowledge of the applicant's circumstances relating to their possession of a firearm or shotguns? Yes. Unless a referee knows an applicant well enough and is able to relate to their possession of shotguns, the reference is useless. That person needs to know you well enough to know that you need guns, want guns, or why you may. Using a reference that doesn't know that minor level of detail about you means they may not be able to give a suitable character reference. Question 7. Should the application form provide a checklist for referees and require a written declaration that they have disclosed all relevant facts? The NGO has no strong views here. A checklist may be helpful, but you don't want to be putting good quality referees off by having them sign a declaration. If someone asked me to sign a declaration, that almost would make me feel like I was way more liable. And that might not be true, but you would hope that a person is giving good quality referees anyway. Question 8. Should the statutory guidance include a more detailed guidance on information that is seeking from a referee? Yes or no? The NGO has, again, no strong views here. The statutory guidance already provides some help and a list of questions for the police, but it probably shouldn't be so prescriptive as to deter referees from the process. A little bit like having them sign a declaration, you're not looking to put people off or make them feel awkward about being a referee, because a referee's not getting anything out of this process other than helping the applicant. The process shouldn't make it hard or tedious for the referees. Question 9. Should the police look at the circumstances when individuals change referees between application and renewal? The NGO recommends the answer to this question is yes. It's already open to the police to ask that question. And there's so many good reasons for a change of referee that it may be completely irrelevant to the inquiry. However, they are free to ask it. What matters most is that the current referee knows the applicant well, and if perhaps you found that your referee didn't know you well enough, or that you had a change of mind that there was a better referee, that should be allowed, and the police should be able to question that. Question 10. Would the sharing of a unique reference number between the applicant and the referee make it easier for the referee to report concerns, decline the reference, or report later concerns to the police? The referee already has your name, your address, they know you well. That's the whole point. They're a character reference. Having a reference number isn't going to help them. It's not going to assist. And most importantly, who is going to keep a reference number on hand for that period of a certificate license life? That's 5 years. You've got to keep a reference number on file. It's a lot easier to remember someone's name, their address, and report that if needed. Question 11. Should the statutory guidance be expanded and made more prescriptive in relation to suitability checks? The latest 2023 version of the statutory guidance already contains an extensive list of questions and checks that the police can carry out. It's not going to assist to add any more. It is already very thorough. Question 12. Should the test as to a person's suitability to be trusted with firearms be based on the balance of probability test? Yes, it already is. It's a test that's been used for many years and has served the police well when inquiries have been handled correctly. Question 13. Should neurodevelopment disorders, types of disorders that influence how the brain functions and alters neurological development, causing difficulties in social, cognitive and emotional functioning, be added to the list of relevant medical conditions in the statutory guidance and the application form? The NGO recommends you answer this question with yes. Some of these are not always identified by applicants and GPs when dealing with applications and GP letters. It doesn't hurt. It's worth having on there. Scrolling on to question 14, should GPs' engagement with firearms licensing process be mandatory? Yes. General practitioners have a general responsibility for public safety, not for the decision-making process in firearms licensing. They should not be able to absent themselves from this responsibility by refusing to cooperate with that medical check part of your firearms licensing procedure. In driving law, they're required to report certain conditions which would affect a person's ability to drive to the DVLA, and they should have a similar role to firearms licensing. I think the answer here is a clear yes. Question 15. Should interim medical checks be made between grant and renewal of certificates? The NGO here recommends you answer no. If the medical marker system is fully introduced and operated by GPs, it will provide a better safeguard than occasional random checks from the police, who as a rule have no medical qualifications. The medical marker check would flag any issues they would be looking for as and when they happen. This seems to be a much better system to me. Question 16. Should the medical marker on GP records of licensed firearms holders be visible to other health professionals? Yes. You don't always see your GP, you might see specialists, consultants, and all those people should be able to report certain things to the police if they have a concern. And there is an issue with security of firearms and the knowledge of where they might be kept, but this is probably outweighed by concerns for public safety. Meaning, I'd rather that people saw you were a firearms holder and made those flagged those markers to the police, than didn't have that access and didn't know where your guns were kept. Most of these people are upstanding members of the community, and there should not an issue with them knowing you're a firearms license holder. Question 17. Should there be more mental health advice and support for licensed firearms holders through advice leaflets and other support? Certificate holders must be able to seek help for mental health problems without necessarily jeopardizing their certificates. I think that's really important to all of us. It's a big concern in the shooting community that you might lose your guns for any mental health issue, and that's actually not the case. Question 18. Should a specific phone line be introduced in addition to the services already available to report concerns about licensed firearms users? No. There are already plenty of good methods to contact the police. 999, 101, Crime Stoppers. Police call handlers must be alert when dealing with or directing relevant calls appropriately in this scenario. However, it's already there. There's already email addresses for firearms licensing systems. There's already things in place. Spending public money on this system seems unnecessary when the system seems unnecessary anyway. Question 19. How should a public phone line be funded? And it gives no yes or no. It's a public or other source. I didn't answer this. Question 21 actually allows you to make comments, and in question 21 I made clear that I didn't think such a phone line was necessary anyway, and no funding is therefore needed. Question 20. Would it be better to raise awareness of existing avenues that are open to raise concerns about licensed firearms holders, 999, 101, Crime Stoppers, Force Firearms Contact, than creating a new phone line? No, I think people are already aware of how to contact the police. I think there is a better way of handling it in that firearms licensing units could open their phone lines all day. They are hard to get hold of in certain counties with very limited hours. I think just making these phone lines open from 9 to 5 would make the whole process significantly better. After question 20, it is just your own personal details. Go through, fill those out. Thank you very much. This is a very important thing for you to do as a license holder. Go and do it now.